Nothing will happen. Thursday. Thursday it will be listed. Not today. About 20? Huh? The request made by the Lana Council appealing for the petitioner. With this matter next week, next date. You will be all right. Be positive. Yes, sir. Sir, Lana Council appealing for the petitioner seeks 1 week's time to do the needful. It is always done. What's wrong in the order? What is the scheme? What is the scheme? What is the scheme so far as compassionate? What is the scheme? Where is the scheme? Next year? When it has been made? When was your father died? Then no scheme is in 2021. If there is no scheme, no compassion. No scheme, there is no scheme, no compassion. First, we dispose this. Let us. Of course, you have not argued the matter. You have not argued, then went to writ appeal, come back again. And the scheme is read it. Liberty after arguing for some time, Lana Council seeks liberty to file review. That is the order. After arguing sometimes only, not made out a case there, then come back. Where is the scheme for providing compensation, compassion ground? It's 21, sir. It's 21 only. Then there was no insofar as the scheme. What you produce is at 2212. ಅದಕ್ಕೆ heard the Lana Council applying for the petition. undisputably the arguing counsel in the review petition. It's not the arguing counsel at the time of making submission in the writ petition. List. This court, by order dated 24th May 2023, at paragraph 5, has arrived at a conclusion that the petitioners have not produced any relevant scheme adopted by the respondent society to appoint the applicants under the compassionate ground. And our counsel today invite the attention of the court to the annexure D to the review petition list. On careful examination of the same, the respondent society has adopted the provisions contemplated under the Karnataka Civil Service Rules, Appointment on Compassionate Grounds Rules 1996, as per the resolution dated 22/12/2021. 21 list. It is also forthcoming from the writ petition that the father of the husband of the petition number 1 petition number 1 died on 11/4/2018, and in that way of the matter, the petitioner has not made out a case that there is error apparent on the face of the record, and any of the declaration of law made by the Honorable Supreme Court in the case of so and so reported in 2020 SCC online SC 896. I am of the view that petition has not made out a case for interference. Accordingly, review petition is dismissed. First, order is confirmed. 50,000 to 10,000. Third, when a counsel Shri B. Pramod, appearing for the respondent number 1, places the order dated 31st July 2023 in writ appeal number 843 of 2023, whereby the division bench of this court, having confirmed the order dated 6/6/2023 in the present writ petition, reduced the cost imposed by this court from rupees 50,000 to the rupees 20,000, to the 10,000 to be payable to the Karnataka State Legal Services Authority within 4 weeks from the date of disposal of the writ appeal. In that way of the matter, the Legal Services Authority, the member secretary, Karnataka State Legal Services Authority shall take appropriate appropriate action against the petitioner. Accordingly, no further orders are required to be made in this. Yes. Impleading applicant as additional respondent. Who has paid? Just 1 minute. Let us will. A1 of 22 is impleading applicant as additional. Maintainability of the writ petition. Well, 1210. Yes. Even intergovernmental, they can file. Good evening. This I know. I only give this 2008 judgment. As intergovernment is, they can file it also. They can file. Even otherwise also. However, it is dismissed. So go before the settlement. Settle if anything is called for, that could be done also. Does not deal with the aspect of it's a reasonable period. Have you read it? Have you read it? Aware about this judgment? What do you say? Take one more copy. That you will read so that we can dispose of in terms of this. Yes, sir. I know that's why. I've seen in that way of the matter, writ petition does not survive for consideration. Yes, very well. Even in the present, in the that case also, that was yes, 2015. Even if the fraud is alleged, delay would defeat the action of the state to unsettle the entries. Who is R1 actually? R1 is died. No, listen. Though IA1 of 22 is filed by yourself. Who are you actually? First, it may be allowed. IA1 of order sheet. IA1 of 22 is filed by the impleading applicant. And taking into consideration the reasons assigned in the said application, comma, I'm of view that the application is liable to be allowed, and the impleading applicant, additional applicant shall be considered as the respondent number 11. Petitioner is 12. Petition is permitted to amend the cast date and to file the amended cast date. This writ petition is preferred. Please sit down. This writ petition is preferred by the state challenging the order dated 28/3/2018 within bracket Annexure A passed by the Special Deputy Commissioner to Bangalore South Subdivision, Bangalore Urban District in RRT proceedings. having heard the Lana Council appealing for the parties and taking into consideration the preliminary submission made by the Lana Council appealing for respondent number 6 and 7, that the writ petition is not maintainable on the ground that this court in WP number 46616 of 2017 disposed of on 9th October 2023, filed by the petitioner state in respect of the sumoto revisional powers exercised by the competent authority under section 136 class 3 of the Karnataka Land Revenue Act has arrived at a conclusion that the petitioner state in the said case has not made out a case for interference in the said case. Accordingly, Lana Council appealing for the 6 and 7 submitted that the finding recorded by the single judge of this court in the said writ petition is squarely applicable to the facts on record. In the guise of the submission made by the Lana Council appealing for the respondents, I carefully examined the order dated 12/10/2023 passed by this court. Undisputably, the petitioner hearing has challenged the order dated 28/3/2018 Annexure A in the present writ petition, urging that the fraud has been urging that there is an element of fraud in suppression of facts before the competent authority, resulting in the passing of the impugned order. However, taking into consideration the observation made by this court in the aforementioned writ petition, as well as the grounds urged in the present writ petition, I am of the view that the delay in exercising the power by the respondent by the competent authority while exercising the sumoto jurisdiction under 136 class 3 could unsettle the entries which has been which is evident in the records that it is continuously stands in the name of the respondents. In that way of the matter, taking into consideration which para that 11th, taking into consideration the finding recorded by the taking into consideration, it is relevant to deduce the paragraph 11 to 14, which reads as 14 in the said writ petition reads as under. Following the declaration of law made by this court, I am of the view that no interference is called for with the sumoto jurisdiction exercised by the competent authority under section 136 class 3 of the Act. In the result, the writ petitions are liable to be dismissed. Both writ petitions are dismissed. Yes. What is challenge? Received a notice. You file reply saying that you are not encroached. No, need not be. Anyway, it is a notice, file reply. Yes. What are all the aspects cannot be considered? They're all disputed question of fact. Yes. Navi, that's why I'm saying take it as a show cause notice, file reply. Another anadhikruta kaಟ್ಟಡವನ್ನು ಸರ್ಕಾರ ಸುಪರ್ದಿಗೆ. ಅಲ್ಲ, if it is anadhikruta, if it's adhikruta, nothing will happen. If you make out a case, it's adhikruta, nothing will happen. File replaces file reply. First file reply to the notice. You know what is challenge is a notice. Let a division bench. Next are R11. 21 order. Page. Filed by him only. Yes. Correct. Fourteen 11/2017. Whereafter an order came to pass by arriving at a conclusion. How can you challenge after the division bench? Already the division bench had taken a. Have you stated about the set writ petition in the? Have you? I don't know. Have you? The clear separation of. What is the extent of government land? There is any called disputed question of land. This is the order of the division. Such disputed facts cannot be gone into by this court under the mediation related to the constitution. The observations made. Even not why went back to the venue of after passing over this ordinance, we went back to the venue. We find it. I have to find the exhaustion.
Commissioner thereafter declined to entertain our appeal on the ground that what since the matter was seen by the Court of Karnataka, I cannot decide this to be take it back to the normal matter. How about this? There is not having a, there is no money in the case. What you have to see the observation of the honorable gentleman. I mean, some report is told that you are the facts. What was examined in that act of declaration spot was the constitutional validity of a provision of law. What is this particular case? Some report is told that those questions cannot be gone into this.
Anyway, 14/11/2017 again you chala.
Reason was because it was not that what was
Maybe. Not a case for it. Not necessary. That is only, let us will see. In this writ petition, no, that cannot. Already the division bench has dismissed. I have read it already. Division, it is only a notice that you challenge. That you have suffered an order in the division bench, and very same order is challenged in the writ petition. Not necessary.
I'm sorry,
not incidents. In this writ petition, petitioner is challenged the order dated 14th November 2017, passed by the respondent authority, within passed by the respondent number 4, within bracket annexure P, and the endorsement produced at annexure O. It is the case of the petitioner that the petitioner claims to be, the first petitioner claims to be the trust, and the second respondent is the educational institution. It is stated in the writ petition that a complaint has been lodged against the petitioner institution by the 6th and 7th respondent herein, stating that the petitioner is in illegal occupation of government land to an extent of 32 cents in survey number 192/1A 3A 1C of Vadera Hobli village, Kundapura Taluk. Pursuant to the same, an inquiry was initiated against the petitioner hearing, a petitioner institution hearing. It is also forthcoming from the writ petition that a public road maintained by the Taluk Development Board, Kundapur, lay adjacent to the land belonging to the petitioner, and further, during the widening of the road by the competent authorities, a portion of the land in survey number 192/1A 3C2 to the extent of 25 cents is the subject matter in the writ petition. Having taken note of the factual aspects on record, the petition hearing has challenged the notice dated 4/5/2021 within bracket annexure P issued by the fourth respondent hearing, stating that the petition hearing has illegally constructed the building in the land belonging to the government, accordingly sought for explanation from the 32 cents, 32 cents from the petition hearing. Hence, this writ petition is filed. Mr. Ajit A. Shetty and a counsel appearing for the petitioners contended that, the notice under challenge is coupled with taking action against the petitioner's hearing and accordingly sought for interference of this court. He also submitted that there is no encroachment as envisaged under the impugned notice produced at annexure P, and accordingly he sought for interference of this court. Per contra, Mr. So-and-so and a counsel, he also submitted that the respondent number 4 has not issued prior notice to the petitioner before issuing the notice dated 4/5/2021 produced at annexure P to the writ. Per contra, Mr. So-and-so and a counsel, Sri J. Jaikar Shetty and a counsel appearing for the respondent number 6 and 7, invited the attention of this court to the order dated 19th January 2021 in WP number 47747 of 2017, produced at annexure R. Submitted that the very same order dated 14/11/2017, which has been considered by this court, has been challenged in the present writ petition and accordingly sought for dismissal of the writ petition. Mr. So-and-so Leonard AG sought to justify the action of the respondent authorities. In the light of the submission made by the Lana Council appearing for the parties, in the light of the submission made by the Lana Council appearing for the parties, I have carefully considered the observation made by this court at paragraph 155. Of this court had an occasion to consider the order dated 14/11/2017, which is impugned in the present writ petition produced at annexure N to the writ petition, and that apart, the petition herein has not annexed the copy of the order passed by the division bench of this court in the writ petition, which would shows the conduct of the petitioner. Full stop. It is also forthcoming from the writ petition that the petitioner has challenged the notice dated 4/5/2021. In that matter, I am of the view that it is open for the petitioner to make reply to the said notice dated 4/5/2021, and in the event if such a reply is made by the petitioner, and same shall be considered by the respondent authorities in accordance with law, taking into account the order passed by the division bench of this court in WP number 47747 of 2007. With this observation, the writ petition is disposed of. Next month. What is this? Bringing LRs of the deceased P1. What is the office objection? What's the office objection? Pass over. Council on record today. Day after today. Day after. List on day after tomorrow. Day after tomorrow. You told day after tomorrow is. Okay, request made by the petition list on day after tomorrow. Non-filing of payment for Prasanna Kumar. Dispose of the review. Even तात्कालिक आपको so negative right cannot be start the Lana Council appealing for the parties. The claim made by the petitioner in this petition with regard to consider the representation dated 24/5/2022 produced at annexure P to the writ petition. Inter alia sought for quashing the provisional order dated produced at annexure N to the writ petition. Having heard the Lana Council appealing for the parties and taking into account the factual aspects on record as the petitioner himself has stated in the said representation that the suit is pending consideration before the senior civil judge Devanahalli in OS number 993 of 2019. I'm up to you that there's no and in that way of the matter, there is no need for the respondent authorities to consider the representation produced at annexure P to the petition. According to the petitions dismissed. Yes. Yes. Anyway, suit is pending. Fraud there. That you have to prove there. No. Nothing else. You yourself has stated in the representation suit is pending. That cannot be done. Yes, next. Dismiss, not a case. No. If you want to now, I can take it. So you sought for cancellation of this date. And this moreover suppression suit. That's what I'm saying. That's what I've stated. Yes, all. Suit, let the suit in the suit it should be considered. Next. Yes, sir. Yes, sir. What your challenge in this order? And what order that you challenge? 136.3. 136.3. File revision. 136.3. 136. First, that may be in the event if any discrepancy, file it a revision. In this petition, petitioner is challenging the order dated 26/9/2022 within bracket annexure K passed by the respond number 3 lister. It is submitted by the learned AGA that the petitioner is having an alternative remedy under the provisions of the Karnataka Land Revenue Act. In that way of the matter, without expressing any opinion on the merits of the case, my liberty is reserved to the petitioner to approach the competent authority under section 136 class 3 of the Act. Interim order is there. Interim order. When was interim order? Interim, it is submitted by after is submitted by the Lana Council appearing for the petitioner. That this court has granted interim order on 20th 6 2023. Mr. In view of the fact that as the Lana Council appearing for the petitioner contended that they will recourse to the revisional jurisdiction under section 136 class 3 of the Act, I'm of the opinion that the interim order granted by this court shall inure to the benefit of the petitioner for 1 month from the date of 1 month from today. Yes. Yes, all contentions of the parties are kept up. Yes, very good. Who has to consider annexure A? Can consider it. You saying that 2 ಎಕರೆನಲ್ಲಿ ಖರಾಬು owns. 2 ಎಕರೆ ಜಮೀನು ಖಾತೆ ಮಾಡುವ ಬಗ್ಗೆ ಕೋರಿರ್ತಾರೆ. Let them consider. Yes. Then file suit for that. Here the prayer is only consider your annexure A. That's a different. That is before a different forums. That is before a different forum. That is before. Just a minute. Impleading is filed by. You want to implead 5. Order sheet accepting the reasons stated in the affidavit accompanying the application. IA 2 of 23 filed by the petitioner is accepted. The impleading proposed respondents shall be arrayed as respondent number 3 to 5. Learned AG accept notice for respondent number 3 and 4, and A Nagarajappal and council accept notice for respondent number 5. In this writ petition, the grievance of the petitioner is with regard to the consideration of the representation dated 2/12/2022 produced at annexure A to the writ petition. It is stated in the writ petition that the petitioner sought for the khata in respect of the subject land mentioned in the representation. In that view of the matter, without expressing any opinion on the merits of the case, the second respondent herein shall consider the same in accordance with law with an outer limit of 8 weeks from the receipt of this order. Accordingly, writ petition is disposed of. Yes. Memo is accepted. Writ petition is dismissed as withdrawn. Yes. Also. Yes. From yesterday's matter. Huh? 2:30. Except 4-1 notification, nothing else. ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿದ್ದು 1000. allowing since land is not acquired, I will allow this petition. That's a different. Only 4-1 notification is issued, not the. But where is the material for that? 6-1. Thereafter 16-2, 11, section 11, then 12-2 notice. There, then 16-2 land acquisition. That has to be made. So in this petition, please. In this petition, petitioner is sealing the order dated 23/6/2023, passed by the second respondent hearing, comma, cancelling the petition granted Somachekara KH, Lana Council appearing for the petition, so and so Lana AG. It is submitted by the Lana Council appearing for the petitioner that the finding recorded by the second respondent hearing is based on the acquisition proceedings initiated by the government in favor of the Karnataka Housing Board, and therefore, therefore it is contended by the Lana Council that as such notification, such acquisition proceeding has not reached finality, the finding recorded by the second respondent requires to be set aside in this petition. Per contra, Mr. Leonard AG so and so submitted that, the notification has been issued under section 4.1 and 6.1 of the Karnataka Land Acquisition Act. It is an act or under the LA Act. However, 6.1 of the Land Acquisition Act, and therefore sought to justify the impugned order passed by the second respondent. Having taken note of the factual aspects and record, the basis for cancellation of the permission granted on 26/5/2023 for installation of housing holding board in the land belonging to the petitioner is based on the fact that the land in question has been acquired for the purpose land has been acquired by the state government in favor of the Karnataka Housing Board. However, undisputably, though the second respondent has stated about the issuance of 4.1 notification, issuance of the notification under 4.1 of the Land Acquisition Act in the impugned order. However, as argued by the Lana Council appearing for the petitioner that the same has not reached finality in acquiring the land belonging to the petitioner. In that way of the matter, the impugned order dated 23/6/2023 passed by the second respondent is without application of mind and not considering the factual aspect of the case relating to the nature of the land. In that way of the matter, the writ petition is allowed, order dated 23/6/2023 within bracket annexure A, produced at annexure passed by the respondent number 2 is set aside. Yes. Anyway, third copy.
I sent you and also committed one more copy.
On the upper check letter. Two statement. Yes, sir. The council appearing for the petition has served copy of the petition to the council appearing for the caveator / respond number 5. Let this matter on Tuesday. Yes. Await service of notice. Tuesday, it may be taken. Tuesday. R7, sir. For R7. You filed power. The counsel, Mr. So-and-so submitted that he has been instructed to appear on behalf of the respondent number 7. Registry is directed to print the name of Mr. So-and-so. Is this matter on Tuesday? Tuesday. Yes. So, will be disposed of within 6 months. Copy subjection is overruled. Then at EG accept notice for respondent number 1 and 2. It is the grievance of the petitioner that the direction be issued to the second respondent land tribunal to conclude the proceedings in the case. So, clearly, case so and so, within bracket annexure A, full stop. Having taken note of the factual aspects on record and as the matter is of the year 1977-78, I am of the view that the second respondent herein shall conclude the entire proceedings within 6 months from the receipt. 6 months from the receipt of this order. Let us proceed. Let them conclude 6 months from the receipt of this order. Notice has to go. Issue notice on IA 1 of 23, 2 of 23, and 3 of 23. Yes. 17 also. Issue notice on IA 1 of 23, 2 of 23. Yes. Let us fix. Lebanese sketch. Yes. What is appropriate? Yes. That is the next one. Even otherwise, can say, but how can you tayar 11 years what is the competency? It's a different thing. Competency. Yes. So you cannot argue the service matter or land acquisition, only KLR, likewise. Same analogy. How can he do that? There's no jurisdiction, even under the notification also. Who is the competent authorities? Where is which 21 Allah? 20? 21 year. Yes. Serial number? 49 years. Respect of orders passed by the survey officers owns. Designation of the officer with whom the powers vested is ADLR. Designation officer to whom the powers is delegated causal. Cannot. But who is the competent authority? As per Annexure B, sir, who is the competent authority to issue? 20, correct. In respect of orders passed by the survey officers below the rank of assistant director, appeals from the origin order, it lies to the AD, that is appeal lies to the ADLR. If the order passed by the survey officer is below the rank of, if it is below the rank of ADLR, then because appeals from the origin order lies to yes, who is according to you competent? Yes. Yes, absolutely. Yes. Anyway, the suit is also pending. Yes. How can he interfere with the that's a different, yeah. How the Tahsildar can interfere with insofar as a matter is already subjudized before the trial court. He cannot say that. So just you read paragraph 2 and 3. And so sahi taale iralladiruvudu duta pattirtade. How can you say that? Signature is there or not? How can you Tahsildar? It's not a forensic lab, the director. Huh? Yes. You can reconsider it. You can reconsider it. Pass of property tax. That you will reconsider it. Yes, because this cannot be stand. Yes. 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 Please run. In this writ petition, petitioner precedence. Petitioner is assailing the order dated 9/4/2013 within bracket annexure A passed by the respondent number 1. It is contended by the Senior Counsel Sri G. Krishnamurthy on behalf of so and so that the first respondent herein has no jurisdiction to interfere with the 11A sketch which has been granted, which has been made earlier, and same has been cancelled by impugned order by passing impugned order at annexure A to the writ petition. It is further submitted by the Lanark Senior Counsel that as a matter is of the civil in nature, the finding recorded by the first respondent herein is liable to be passed on the ground that the disputed question of facts are involved in this petition, accordingly sought for interference of this court. Per contra, Mr. So-and-so, Learned Counsel, Learned AGA, so-and-so sought to justify the impugned order passed by the respondent number 1 and also refers to the notification dated 6th May 2005 produced at Annexure B to the writ petition. Having heard the Learned Counsel appearing for the parties and taking into consideration the finding recorded by the first respondent hearing per se is evidenced. It is evident from the Annexure A that the disputed question of facts are involved in this petition, and the respondent number 1 has cancelled the earlier 11E sketch made on 27/11/2012 in respect of the land in question on the ground that the fraud on the ground that there is an element of fraud among the petitioner as well as the contesting respondent. Full stop. In this regard, I have also noticed that the suit in OS number 104 of 2011 is pending consideration before 1. I've also stated that the civil suits are pending consideration between the parties. In that view of the matter, I'm of the view that the first respondent hearing would not have interfere with the title of the title to the property in question, which is in the domain of the civil court. In that view of the matter, I'm of the view that the order dated 9/4/2013. When was the order passed? 9/4/2013. Annexure A passed by the respondent number 1 is hereby set aside, and the parties are abide by the adjudication of the suit pending consideration before a competent court. Court 61. Yes. Pending civil court. That's pending suit/miscellaneous petition. Suit/miscellaneous. No, that's a different. You cannot encroach the domain of civil court. Yes.
But in this matter,
R4 to R9, who appears?
yes, the contesting the respondents, I have to file because I was not well, I could not represent. I'm sorry. So 1 week time may be granted, in the meanwhile, I will take steps to the contesting respondents.
The petitioner has to say. Petitioner has to say this. That will take notice. Let us will.
Please. That interim order should be extended.
What is challenge in these petitions?
They say that the road was encroached by
Not
the.
so. So appeal lies to 49.
Yes.
49. So it's an appealable order, sir.
But I will verify. Kindly have it next week. I will submit before this court.
Anyway, it's appealable order. There's no. If you file an appeal, let us will see. Let us will see. Heard the Learned Counsel appealing for the parties. Shri S.C. Shivaram, Learned Counsel appealing for the respondent number 3, argued that the order impugned dated 11/1/2023 produced at Annexure A, passed by the respondent number 2 is an appealable under the provisions of the Karnataka Land Revenue Act. Accordingly sought for dismissal of the petition on the ground of exhausting the alternative remedy by the petitioner. It is submitted by the learned AGA that in view of the pendency of the petition, it is difficult, the respondent authorities are not in a position to allow the public to encourage into the as the respondents herein have directed the petitioner to remove the encroachment made in the cart road, full stop. Existing cart that we have full stop. However, the submitted petition hearing is not interfere with the existing cart road as alleged by the learned AGA. However, in view of the factual aspects on record, that as the remedy is provided under the Karnataka Land Revenue Act against the order passed by the second respondent under section 104 of the Act, you have to view that the liberty is reserved to the petitioner to approach the competent authority in accordance with this. Yes. IA, except in the reason stated in the IA 123 and 223, applications are allowed. Order dated 12/6/23 is set aside and the writ petition is restored on file. Yes. Issue notice. Leonard AG accept notice for the respondents. So what is the matter? Just I will ask. Yes, what is the matter?
But in my matter, Malad,
Yes.
Sorry, Malad.
Yes,
for
sir.
money, I requested for a limited period the interim order to be continued.
The interim order was there earlier?
It was there, Malad. After hearing
in order to provide opportunity to the petitioner to avail such remedy under the Act, the interim order granted by this court shall be continued for another 4 weeks from today. Yes.
Grateful.
Yes. Yes. What your challenge? Annexure P is challenge. Yes. 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 Well, anyway, it is a matter of civil in nature. Mandatory injunction. Yes. File a suit, seek easement right. That's all. Two? Yes, correct. Deputy Commissioner passes an order to clear the ಸರಿ ಜಮೀನುಗಳಲ್ಲಿ ಸಾರ್ವಜನಿಕರು ಇವರಿಗೆ ಸಂಪರ್ಕ ಇಲ್ಲ. Yes. Yes. Whether the road is there or not, whether that could be taken into consideration by the revenue authorities, that they cannot. Whether the suit is also pending.
Or injunction against me.
Yes.
Altogether, the question of road regard is not there. And whether they have cookie rights or not is also not asked. So the authorities have given the report, but they do not have cookie rights. So only comes the next paragraph.
Yes.
The government land, the deputy commissioner should be reviewed given the land of.
Anyway, this suit is pending.
That is the law.
And whether you have a easement right over the property or not, irrespective of this, whether that cannot be that cannot be gone into in this aspect.
My grievance is this person, this is government land. To be treated as not the land of a private party, that is responsible. Should not be violated the article. Not annexed, please 23 annexed A.
Yes.
70 Sarkar. Then not annexed, please 24 annexed A. 71 A.
Yes, Mr. Anandram says this is a disputed question of facts are involved. Whether the road is there, whether it belongs to the government or it belongs to the petitioner or contesting respondents, that has to be decided in a.
70 bar 8 and 71 bar 8 admitted the government property. It is over this government property, respondent of all claims to give rights, which the government says is not there.
You are.
Over this government property.
You can.
This property, I have given my consent.
And moreover, I think insofar as your case is concerned, it is government has yet to take decision insofar regularization. Then that's why. That means you have no legal existing right. Maybe in possession, but you have no existing right. Insofar as yes, sir. So these are, anyway, that's why that is why the deputy commissioner would say that insofar as the ಯಾವುದೇ ರೀತಿಯ ಕ್ರಮ ನ್ಯಾಯಾಲಯದ ಇತ್ಯರ್ಥವಾಗುವವರೆಗೂ ಕಂದಾಯ ಇಲಾಖೆಯಿಂದ ಯಾವುದೇ ರೀತಿಯ ಕ್ರಮವನ್ನು ಕರೆಕ್ಟ್ ಆಕ್ಚುಲಿ. Yes, that you can challenge in a different. That cannot be. Anyway, the suit is pending. Whether these are all the disputed facts. Maybe. Yes.
Connection J. It is filed by respondent number 5 A.
Yes. Yes.
For government intention, it is decision number 1 is made servants will interfering with the people for the employment of the B should be proper.
Yes.
70 bar 8 and 71 bar 8.
Yes.
These are like
yes. Because only you also filed a form number 53 for seeking regularization. That is also pending. No. No. This court held that mere filing the application cannot grant any.
The property cannot be considered to be their property.
They are not stated that it belongs to them. They are not stated. Survey number ಅಲ್ಲಿ ಸರ್ಕಾರಿ ಅನಾಧೀನ ಸ್ಥಳವಾಗಿತ್ತು. They did not say. Second line, please see. ಮಾಣಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸರಲ್ಲಿ ಸರ್ಕಾರಿ ಅನಾಧೀನ ಸ್ಥಳವಾಗಿತ್ತು. Yes. But in the second line, you see that ಸರ್ಕಾರಿ ಅನಾಧೀನ ಸ್ಥಳವಾಗಿದೆ. See, they cannot confirm the title in respect of the property. Yes, even the that has to be read along with the second line. Sarkari anadina sthalavagide. Second line it is stated. Categorically say that the deputy commissioner would say it is a government land. Government land, but he can utilize that for the purpose of ingress and egress. That's it. Yes. Yes. That cannot be. That I will clarify. That I can. File suit for that. File suit for that. Those are all the aspects cannot be in under 226. Yes. August. 28th of August.
In the light of the question as to whether the respondent has any rights of the land and circumstance to the certitude of the rate is decided. All parties are directed to meet the status of this nature of the problem. Neither the respondent will exercise duty rights of the excavated party, nor the petitioner will use the excavated land at cost. Now, what happens here? He gets an interim order. It is number 39 along with the founder that produced the big private stand. For hearing on 9th August.
Yes.
In spite of the interim orders, they continue. They continue even after, in spite of not having been granted. After the discount puts its status quo to maintain, they still further continue to work.
Anyway, you can resolve in the civil court.
Let there be an injunction that the disposal of this.
Yes.
Let there be a direction to dispose of this.
No, that cannot be. Even that cannot be done in K. That cannot be done in WPKLR.
He takes the road after the.
Let us see. Yes.
subsequent matter. Case number 2 of Impleading. Case number 2 of.
No, anyway, I will consider it on merits. I will consider.
Photographs for the along with the counter.
Yes, sir.
Page 36. The date is 9th August. Is
Nine- one-
they do the work on 9th August.
98.
Oh, respect.
Only take the motion arrested. My children did not go to school.
That cannot be.
After the interim order of 28 is 38 and all of that.
98. 98. Yes.
September. Along with the additional counter.
Additional count.
4th September date is only that photo. It's not the registered son.
Those are my children.
Photographs.
My children going to school, they have taken photographs to say I violated the interim order.
All
The
this.
parents not go to my house.
I can see page 42.
Let us wait. In this writ petition. Yes, let us wait. In this writ petition.
Number 2 of the order. But third time, in the event of hardship declaring the operation of interim order, the petition is entitled to move it. Has made a representation to the Tribunal of 5/9/2023, but requesting not to continue. Therefore, please understand,
Let us wait. That you can file a suit for that. That you can file. Indian
Sort of approach. Point to more action.
Let us wait. In this writ petition. Third is, in this writ petition, please sit down, please. In this writ petition, petitioner is assailing the order dated 29/5/2023 within bracket annexure P, passed by the respondent number 2, comma, holding that the matter is of the civil in nature and accordingly directed the fourth respondent herein, comma, not to take any further action in respect of the land in question. Please sit down, please. The relevant facts for adjudication of this writ petition are that the petitioner claims to be the owner in possession of the land bearing survey number 142/4B, measuring 1.44 acres, situate in Barimaru village, Bantwal Taluk, full stop, Bantwal Taluk. It is stated in the petition that the occupancy rights in respect of the said land has been granted by the jurisdictional land tribunal. It is the case of the petitioner that the respondent number 5 herein claiming ownership in respect of the survey number 142/7, measuring 1.37 acres in Barimaru village, Bantwala Taluk, and the western side of the petitioner property is situate in survey number 70/8, and to the southwestern side is the survey number 71/8 in Mani village, Bantwala Taluk. It is stated in the writ petition that the petitioner has the son and daughter of the petitioner, son and daughter-in-law of the petitioner have made an application in form number 57 seeking grant of land as per annexure B to the writ petition, and the respondent authorities are yet to take decision in the matter. It is further stated in the writ petition that a proposal has been sent to the Assistant Commissioner, Jurisdictional Assistant Commissioner, based on the report made by the Revenue Inspector regarding the formation of the road in the subject property. However, the Assistant Commissioner by letter dated 6/2/2023, sent back the file with a revised sketch, and a report as per letter dated 6/2/2023, Annexure B. However, full stop. It is also averred in the writ petition that the respondent number 5 has filed suit against the petitioner in OS number 254 of 2020 on the file of the principal civil judge within bracket junior division and JMFC Bantwal seeking relief of injunction, and the said suit is pending consideration before the trial court. In that way of the matter, the grievance of the petitioner that the respondent number two has directed the respondent number 4 by letter dated 29/5/2023, Annexure P, holding that the land which is being utilized by the petitioner is belong to the respondent number 5, and being agreed by the same, the present writ petition is filed. I heard Mr. Anandram, Lana counsel, so and so for the petitioner. She is so and so Lana senior counsel appearing on behalf of respondent number 5, sir. On behalf of Pradyumna Shekhar for respondent number. Yes. Okay. That I was. It's respondent number 5. Sri Anand Ram Lana counsel appearing for the petitioner invited the attention of the court to the impugned order produced at Annexure P, and submitted that the second respondent has passed an order, holding that the land being utilized by the petitioner is belong to the respondent number 5, and such a finding recorded by the respondent number 2 is contrary to the factual aspects on record. Accordingly, he submitted that, in the event if the writ petition is not interfered with by this court, the family members of the petitioner cannot utilize the land in question for their ingress and egress, and accordingly sought for interference of this court. Per contra, Mr. So-and-so, a senior counsel appearing for the respondent number 5, contended that the petition herein are not the owner in possession of the land, and they have made an application to the competent authority seeking regularization of their land, and in that way of the matter, the writ petition deserved to be dismissed on the question of maintainability itself. Further, it is contended that the respondent number 5 have taken respondent number 5 has stated that the land being utilized by the respondent number 5 is a Kumki land, and therefore the petition is having a beneficial Kumki land, and therefore they can utilize land for the said purpose. In that way of the matter, it is submitted by the Lana senior counsel that as the land in question referred to in the annexure P being a Kumki land, and the respondent number 5 is having a beneficiary of the said land, and in view of the pending suit before the competent court, the writ petition is liable to be dismissed. Per contra, Mr. Lana so-and-so Lana AGA sought to dismiss the writ petition on the ground that the disputed question of facts are involved in this writ petition, accordingly sought for dismissal of the writ petition. In the light of the submission made by the Lana counsel appearing for the parties, it is not disputed by either of the parties before this court that the petition herein has made the son and the daughter-in-law of the petitioner have made an application to the competent authority seeking regularization of their land as per annexure B, and the said application is pending consideration before the competent authority. Petitioner, son and daughter-in-law as per annexure B, and the same is pending consideration. In that view of the matter, mere filing the application does not confer any right over the petitioners in respect of the land in question until the said application is to be considered by the respondent authorities in a manner known to law. Full stop. Secondly, I've noticed that the respondent number 5 herein has filed suit before a competent court in OS number 254 of 2020 against the petition herein, and same is pending consideration before the court. So, though the Lana Council appearing for the petitioner contended that the said suit is for seeking relief of permanent injunction against the defendants / petitions hearing. However, the same cannot be, however, the said submission made by the Lana Council appearing for petitioner cannot be accepted until the disposal of the suit by the competent authority, taking into consideration the fact that the land in question is a funky land. That is no, it is yet to be decided. I said it. Yet to be decided. And the question relating to the Kumki land is also to be adjudicated in the said suit. However, I have also noticed that the second respondent herein at annexure P has stated that the land bearing survey number 70/8 and 71/8 is the government land / Kumki land. In that way of the matter, I do not accept the submission made by the Lana Council appearing for the petitioner that the respondent number 2 has decided the title in respect of the land in question in favor of the respondent number 5, despite the fact that the suit is pending consideration before the court. In that way of the matter, I'm up to you that in the event if the petitioner is required to use the said land for his ingress and egress, it is open for the petitioner to approach a competent court, civil court, for redressal of his grievance. With this observation, petition is dismissed. Yes. Yes, sir. That is always in the event, provided if you file a suit. Provided if you file a suit. No, that's that's why I said it. Say the government Kumki land. Kumki property. That's what he stated. That is. Anyway, that is always there. No, it is yet to be decided. That's why I say. No, nothing will happen. Nothing will happen. Anyway, his application is pending consideration. First, that is different. Not in this. Let us fix it. Yes, Ravi Shankar. No, that's it. Anyway, the finality reached finality by dismissal. No, nothing else. It is merged with final order. By dismissed. Yes. Yes, Ravi Shankar. No, that is always there, sir. That is always there. Yes. Correct.
Before that, subject matter before the commissioner and the parties.
Yes.
Commissioner passed an order saying that the part is portion of the It's pretty apparent before the next.
Yes.
Learned single judge accepted the petitioner's order.
Yes.
There was now years of persecution. Division bench is part and order of this. Pendency. And it's a file.
Yes.
Page 202.
Yes. That's a learned single judge.
182. 182, 186, paragraph 3, line 3. We deem it appropriate direct respondent to Commissioner Department of Federal Assessment and submit a comprehensive report by undertaking a fresh exercise to conduct a measurement of the area of additional material information with regard to details of grant, names of the grantees of the state land, and the details of litigation. In the aforesaid process, respondent to will also undertake the exercise of 40 of the file.
Anyway, at paragraph 5, the division bench stated we make it clear that the court is not passing any order with status and position. Till then, no further proceedings. Five. No, nothing else. Let the notice. Preliminary is yet to be started.
Impleading application. I gave a background fact. On the ground that the impleading applicant has no extra stand before this court and my petition challenging the order. Because he is the great, he has to come with an independent petition.
Even otherwise, he has to. Yeah. Anyway, stays there. Let it be there. Nothing else. Anyway, you approach the division bench. Matter is pending consideration. Have you read the paragraph 5 of the order? Yes. The order is passed against you actually, not to do anything else. That's why in paragraph 5, the division bench says so. Let it be considered at the. It is not at this stage. To be considered later. No. It may be taken up a list after 3 weeks. Interim order granted earlier, extended till next set of hearing, list after 3 weeks. Await the order. Await. This matter after 3 weeks. Await the order to be passed by the division bench in writ appeal number 755 of 2023. Let us. No, I'm not saying that. Make out a case there. You make out a case in division bench. It is you are the appellant. No, next matter. Next matter. No, I'm not passed any order. I say that await the division bench order. That cannot be. That cannot be. Sir, now I have not passed any order on impleading application. Sir, await division bench order. Then I have to dismiss your application. Can I dismiss your application? If you want, I can dismiss your application. Yes, Raghavendra. Yes, ma'am. Which order that you challenge? Yes, sir. Additional Deputy Commissioner's motion. It is a Mysore Religious and Charitable Incomes. Yes. From the records, is found that the land in question is a Devadaya Enam land attached to the temple, so and so. It falls under the ambit of the Mysore Religious and Charitable Enam Sabalichana. What is the circular says? Where? Yes, it's also clarified that circular number 3897, that's a previous circular, in which it was stated that the deputy commissioner would exercise their powers under so and so. Connected queue. Yes. Yes. The application received before the last date fixed in the certain so and so, that is so and so, have to be dealt with the land tribunals. Where it is stated? Yes, where it is stated? Yes, where in the second para? Paragraph start with the application received. 75. Which para now you are reading? Third para in page 74. There's no third para actually. There's no third para. It's only one para actually. Which para you are reading? With reference to your letter. From direct to clarify, 7A application received under 77 of the land reforms are two in had to be dealt with by the assistant commissioner or any other officer of the same grade. And specifically, now what has happened now? When he has passed an order, how he has passed an order? But it was remanded by the KET. That's okay. Not been brought on record and issued notice. But as per circular, how can the deputy commissioner pass now? Even otherwise, but where is the order passed by the KET? Annexure H. ಎರಡನೇ ದುರದಾರರು. That is Upavibhagadhikari. But here the AG accept notice for respond number 1 to 4, issue emergent notice to 5 and 6. In the meanwhile, stay of annexure vote dated 4/8/2022 in LRF number 669 of 99 and 2000 until further orders. Let us will. Yes. Yes. Annexure M 67. What is challenge? Hmm. Now, what is the material? What is the material that you have shown before the? But you go to annexure 67 for 1 minute.
Land is in my name. And possession, the records are also in my name. After 88 records granted, then they are given. They have granted control, then I approach the council for direction.
Correct. Correct.
Court has issued a positive direction.
50? Yes. Yes.
The land in question was declared as Pada for non-payment of the arrears of land. The problem is stated to be found in 1988. Except for revocation of the classification of the land as Pada and to accept the arrears of land. Revenue and restore the land to D. Next is found the restore. We might use the traditional solid. Offering to clear the arrears of land revenue, the deputy commissioner is bound to consider the payment for the appropriate orders regarding calculation of land revenue.
It's only nothing but consideration your plea. That is not. But now you have to produce the relevant document.
Relevant document. Because the deputy Tahsildar and the deputy commissioner, they are supporting the instead of filing the record from the Tahsildar.
What you have produced? You go to page 60. Go to page 67. 10th paragraph. ಮೂಲ ಕಂದಾಯ ಮತ್ತು ಸರ್ವೆ ದಾಖಲಾತಿಗಳಂತೆ no. Read 67. Yes. Let's say that how you got acquired this property. That is the question. How you had acquired these properties?
But this property is not. Admittedly not kindly seen the government because next to that what are the observation here by the exam?
No, how did you acquire these properties?
This is my property because from analysis
How? Maybe. That is disputed. No. Let the notice will. No. Leonard AG. No. Correct orders. That we will get it. Issue Leonard AG accept notice for respondents. Yes. No, that cannot. This is correct actually. Order is correct prima facie. Yes, next. Under AG accept notice for respond number 1 and 3. Issue emergent notice to 3 to 3 to 12. In the meanwhile, the stay of order dated 27/12/22 in appeal number 139 of 2018 on the file of Karnataka Appellate Tribunal at Bengaluru within bracket annexure A till next step. Yes. Who are you actually? Who is the petitioner? Huh? What is your right? Annexure E is challenged. What is wrong in the order? When did you purchase? 16? On 6/1/2020, who is the owner? Where is your sale deed actually? Next year? Hear him pass order. Notice was issued to his vendor. You hear him and pass order. Standard EG accept notice for respond number 1 to 3. In this petition precedence, in this petition is assailing the order dated 6/1/2020 within bracket annexure E passed by the respond number 2. It is the grievance of the petitioner that the order dated 6/1/2020 within bracket annexure E passed by the second respondent is in respect of the vendor of the petitioner dash respond number 4 herein, and therefore the second respondent herein has passed an order without hearing the petitioner and accordingly sought for interference of this court. Having taken note of the factual aspects on record, that the petitioner is originally the owner of the land in question and he has sold the property in question to the respond number 4 as per registered sale deed dated 16/9/2017 within bracket annexure A, and thereafter purchased the very same property from the respond number 4 as per registered sale deed dated 16/8/2018 within bracket annexure D. In that way of the matter, I have to view that as the petition herein has not been heard by the second respondent hearing while passing the order dated 6/1/2020 within bracket annexure E. I have to view that the petition has made out a case for interference. Accordingly, the writ petition is allowed. Order dated 6/1/2020 annexure E passed by the respondent number 2 is set aside and the matter is remitted to the second respondent hearing to pass appropriate orders afresh after affording opportunity of hearing to the petition. Accordingly, writ petition is disposed of. Yes. 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 Which order that you challenge? How it could be interfered after this length of time? Para 8. Para? Hello, why you are not approach this court at the earliest point of time? No. You say why this order was after 17? Delay of 17 years. Delay of 17 years. No. Sorry. But you can give notice. I cannot. That's a different. 17 years. Leonard AG accept notice for respondent number 1 and 2. In this petition, please heard the Leonard counsel appearing for the parties. In this petition, petitioner is challenging Please sit down. Portion of the order dated 28/11/2006 passed by the second respondent hearing within bracket annexure. It is first having heard the learned counsel appearing for the parties, I am of view that the order impugned is passed in the year 2006, and the challenge before this court in the present petition after an inordinate delay of 17 years from the order passed by the second, from the order passed by which respondent? By the second respondent hearing. Full stop. Having taken note of the governments made in the writ petition with regard to the explanation offered by the petitioner with regard to condone the delay of 17 years, and same cannot be considered as a sufficient ground to condone the delay of 17 years delay in challenging the impugned order passed by the land tribunal. Accordingly, following the declaration of law made by the apex court in the case of state of Nagaland versus Lipak, reported in 2005, so and so, I'm of the view that the petition cannot be accepted and liable to be dismissed on the ground of delay and laches. Yes. 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 Let the notice will go. Then at AG accept notice corresponding to 1 to 3, issue emergent notice to 4. Let us will. No. So gift deed is has to be proved. Let us will. Anyway, the gift deed is a question that has to be. Let us will. Whether it could be considered. But let us will see. Prima facie not a case for granting increment. Nothing will happen even if it changes. Next matter, let us listen. After 2 weeks. No representation list after 2 weeks. Yes, 1 minute. No, just 1 minute, 1 minute. 1 minute. Yes. 32. 30, yes. Yes. And again on that they will take instructions in them. Then at AG accept notice for respondents. Get instructions. Yes, sir. Let us, we will get, say 23. What's who has to consider? Who has to consider? Yes, purchase it, just then at AG accept notice for respondents. In this, please sit down. Please sit down. In this petition, the grievance of the petitioner is with regard to the fact that the petitioner has made an application to the respondent number 4 to change kata pursuant to the order passed by the competent authority. In that way of the matter, without expressing any opinion on the merits of the case, The fourth respondent shall consider the representation dated 10/8/2020 within bracket annexure B with an outer limit of 8 weeks from the receipt of this order. Accordingly, writ petition is disposed. Yes. Raghu Prasad? Suit is pending. Suit is also pending. No representation, list after 2 weeks. Yes. That is right. ಕೃಷ್ಣಮ್ಮ ಅವರಿಗೆ ಜಮೀನು ಮಂಜೂರಾಗಿರೋ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ. That is the finding record. That the notice will be. Under AG accept notice for respondent number 1 to 5. You are representing Sri Rakesh B. Bhatt, represented for respondent number 6 as a KVH. Get instruction. Let us read this. No. No. We will see. Next matter. No. 2 weeks for them. 21st. Yes, sir. Consider his claim. Under AG accept notice for respondents. Notice is ordered. It is the grievance of the petitioner that notice again. It is the grievance of the petitioner that the respondent number 3 is 3 shall 3 has not considered the representation made by the petitioner dated 5th August 2023. In that way of the matter, without expressing any opinion on the merits of the case, the third respondent shall consider the annexure G at the outer limit of 8 weeks from the receipt of this order. Accordingly, the petition is disposed. Yes. Yes. Same, I think, serial number 35, 42, 49, 50. They are all relating to the same. Issue emergent, Leonard AG accept notice for respondents. In the meanwhile, stay of order dated 8/6/2023 passed by the respondent, passed by the second respondent. Same in say number 42, 49, and 50. Same order. Yes. What mandamus is out for? What's mandamus? Huh? No, not covered. What is your case? It is a Gomad land. Then? Yes. That's correct. Yes, to. No judgment. According to you, it is a Gomad land. You are saying that ಕಂದಾಯ ಅಧಿಕಾರಿಗಳು ನಿಮಗೆ ಮಾಡಿಕೊಟ್ಟು ಕೊಡುತ್ತೇವೆ ಅಂತ ಹೇಳಿ ಹೋಗಿದ್ದಾರೆ. ಅವ್ರನ್ನೇ ಕೇಳಿ ಪರವಾಗಿ. Cannot be considered. No, that cannot be. Maybe on the different facts. Maybe on different. In this petition, petitioner has sought for Leonard AG accept notice for respondents. Respondent. In this petition, petitioner sought for consideration of the representation dated 16/8/2023 within bracket annexure A and to issue the Sagavali chit in respect of the land in question. Having heard the Lana Council appealing for the parties and taking into consideration, it is reflected in the representation dated 16/8/2023 that the land in question is a government land, government Gomal land. In that view of the matter, we have to view that the petitioner has no legal right to claim the said property unless the claim the said property claim the relief as sought for in the said representation. And in that way of the matter, the writ petition is dismissed. Yes.
I appear for the
Yes,
petitioner.
who has to consider annexure G?
The respondent Tahsildar.
Maybe.
The inheritance blood.
Inheritance seeking
Yeah,
after the death. And AG accept notice for respondent. The grievance of the petition is with regard to the transfer of Khata stands in the name of the deceased P. Kodandarama Reddy, within bracket father of the petition. Without expressing any opinion on the merits of the case, respondent shall consider the representation dated 26/4/2023 annexure G within outer limit of 3 months from the receipt of this order. Accordingly, the petition is disposed of.
Right.
Yes. File representation. File representation. No, that is a legal notice. In the legal notice, you said in the civil ನ್ಯಾಯಾಲಯದಲ್ಲಿ civil ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹೋಗಬೇಕು. File one more representation, let David. According to you, you say that civil ನ್ಯಾಯಾಲಯ, not this. So then I will say that consider go to civil court. Can I say? That cannot be. In this list of Leonard AG accept notice for respondents. After arguing for sometimes, Mr. So-and-so and a counsel appealing for the petitioner submitted that the petition herein has already sent legal notice produced at annexure F to the respondent authorities and also further submitted that the petitioner will make one more representation to the respondent number 4 to 6 seeking relief as claimed in the said legal notice. In that view of the matter, if the petitioner makes such a representation to the respondent number 5 to 6 within 4 weeks from the receipt of this order, then I can say F may be considered. Well, take it. Leonard AG, the grievance of the petitioner is with regard to the consideration of the representation dated 5/11/2022 within bracket annexure F seeking change of mutation in respect of the subject land without expressing any opinion on the merits of the case. The respondent number 4 shall consider the representation dated 5/11/2022 produced at annexure F within the outer limit of 3 months from the receipt of this. Accordingly, the petition is disposed of.
So petitioner, serial number 39.
Yes.
Yes, ma'am. But that's petitioners, the MR which came to be affected in the name of petitioner.
That has been changed.
Changed, my lord. Despite there is a pendency of civil suit which was filed by respondent number 4 to 6.
How can you pass it, sir? Deputy Commissioner. The order passed by the Assistant Commissioner is well reasoned, and something is happened to your Deputy Commissioner to pass an order, and not a speaking order also. Not a speaking order also. A detailed order has been passed by the Assistant Commissioner, and the suit is pending. Let there be a stay. Let AG accept notice for respondent number 1 to 3, issue emergent notice to 4 to 6. In the meanwhile, stay of order dated 6/12/2022 in RP number 8 of 2021 on the file of the first respondent within bracket annexure A until further orders.
Much obliged.
Yes. What your challenge? Annexure G. Yes. 57. Yes. ಎರಡನೇ ಎದುರುದಾರರು just 1 minute. ಎರಡನೇ ಎದುರುದಾರ means ಎರಡನೇ ಎದುರುದಾರ ತಹಸೀಲ್ದಾರ್ ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ. In the earlier the Tahsildar. According to I said Tahsildar is died. ವಿಚಾರಣೆ ವೇಳೆಯಲ್ಲಿ ಸೋನ್ಸ ಅಂದ್ರೆ ಪಾವತಿಯಾಗಿರುತ್ತಾರೆ ಅಂತ ತಿಳಿಸಿದ್ದು ಮರಣ ದೃಢೀಕರಣ ಪತ್ರವನ್ನು ಸದರಿಯವರು ವರ್ಷವನ್ನು whether the LRs have been brought on record.
I have tried a memo where I am the person that purchased it. I can even begin that this property has just hold in my way. It has been produced. I can place it at a registered of I is earlier.
That is what.
He has filed a civil suit.
And that even suit is. That is one. Oh no, 1065. Insofar as is filed by this Krishna Jira Yadriki Wadi Sons. Insofar there are two. Insofar as 4 suits are there. 153, 1065, 83. Yes. Even take for an example, even if the respondent number 2 in the said revision petition is brought on record, however, insofar as is respondent number 2 is only the vendor. Even otherwise, anyway, the matter is the civil suit is. Who? ಈ ಬಗ್ಗೆ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ ತೀರ್ಮಾನಿಸಬೇಕಾದ್ರೆ ಕಂದಾಯ ಸೋನ್ಸ. Then the order is correct. Yes. Even take for an example the abates insofar as R2. What will happen? Yes. No, civil suit. Anyway, the matter is seized by the court. Let the civil court will take decision. No. Anyway, civil court is matters pending before civil court. Let it go. Anyway, insofar as there is no infirmity in the order as such. Nothing. Anyway, establish your right before the court. Anyway, there is no insofar as the infirmity in the order as such. Anyway, this suit now there are 2 suits are pending. One is concluded. 153 is now it is concluded. 1065 of 2000. Raj, now only the 83 of 2018. Just one. 83 of 2018 is fine. And one more. Just one. First one. 933. It is also pending. It is anyway filed by yourself. Yes, see the outcome of this thing. Anyway, whatever may be the thing, it's outcome. Leonard? Yes. Anyway, let the meeting. Leonard AG. Leonard AG accept notice for respond number 3 to 5. You are appearing for? Satish, Nitish, sorry. Nitish appearing on behalf of the respond number 2 as a KVH. Heard the Lana Council appearing for the parties. In this writ petition, the grievance of the petitioner as contended by the Lana Council appearing for the petitioner that the petitioner has purchased the land bearing survey number 12/2. Please sit down. 12/2 of Doddabettahalli, Bangalore North Taluk, measuring to an extent of measuring 1 acre 24 guntas of the land, including 0.4 guntas of Karab, as per the sale deed dated. As per sale deed dated 24/6/2016, within bracket annexure A. Full stop. It is contended by the Lana Council appearing for the petition that pursuant to the sale deed dated 24/6/2016, executed in favor of the petitioner in respect of the land in question, the Krishnoji Rao has executed a registered will dated 27/11/2015 in favor of his 3 sons, namely Girish Putani, K. Rakesh and K. Mahesh Putani, in respect of the extent of 0.371 guntas out of 2 acres 20 guntas in survey number 12/2 of Doddabettahalli village, Bangalore district with Yelahanka Taluk. In this regard, he contended that the finding recorded by the 5th respondent herein at annexure G to the writ petition that the matter is of the civil nature be accepted. However, it is his categorical submission that the kata, insofar as the property in question, has to be restored in the name of the petitioner hearing. Accordingly, sought for interference of this court. Per contrast, Sri Nitish Lana Council appearing for the respond number 2 refers to the pending suits before the competent court in OS number 933/2017, filed by the petitioner hearing against the respondent's hearing, as well as OS number 83/2018, pending consideration before the competent court, filed by yourself, filed by this respond number 2, relating to the title suits, and unless these 2 suits are concluded, the kata in respect of the subject land shall stands in the name of the contesting respondents here. Leonard AG so and so sought to justify the order passed by the respondent number 5. Having heard the Lana Council appearing for the parties, on careful consideration of the impugned order passed by the respondent number 5, would indicate the suit filed by the petitioner hearing in OS number 933/2017 with regard to the declaratory relief is pending consideration before the competent court, and in the said suit, the respondent number 2 has been arraigned as the defendant in the said proceedings. That way of the matter, as the declaratory suit filed by the petitioner itself is pending consideration before the competent court. And that apart, the respondent number 2 has also filed a suit in OS number 83 of 2018 against the petitioner hearing before and against the one against the trust against the 6th and 7th respondent hearing, and same is pending consideration before the competent court. I am of view that the finding recorded by the by the 5th respondent hearing is just and proper, and therefore I do not find any illegality in the said order passed by the 5th respondent hearing. Accordingly, petition is dismissed. File respective application before this. File respective. You can file an application through online. No, you can file an application online, madam, as per law. That we cannot. That is up. If I frame the time limit, tomorrow I will get 1,000 petitions. That AG accept notice for respondents. Next, the respondent, then AG accept. No, that cannot be considered, madam. You can make an online. No. From the date on which you make online application, you can make after 1 year also, no problem. Now you can make an application online that they will consider. Then at AG accept notice for respondent. It is the grievance of the petitioner with regard to consider the representation dated 11/4/2023, sorry 3/3/2018, 10/2/2022, and 11/4/23, produced at annexure E, G, and H respectively, seeking affecting code in respect of the subject land. And at AG submitted that it is open for the petitioner to approach the respondent number 4 through online application seeking coding of the land in question. That way of the matter, that the petitioner is open for the petitioner to approach the competent authorities through online application seeking relief of coding of the land in question. If such an application is made through online, same shall be considered in accordance with. When was the order passed? When did you come to know about this? When the acquisition was made? Let the notice will go. Maybe true it is 80/81 order. Yeah. Then at AG accept notice for respondent number 1 and 2. Issue emergent notice to 3 to 5. Let us fix it. No, nothing. Land tribunal order is passed now, challenge now, that cannot. See, but now the land is acquired. Now you are challenging the title to the property. No, land tribunal is nothing but conferring right. That is nothing but granting right in favor of. Let us will. No. 1988, that cannot be interfered also, of course. Let us will see. No. Sir, 80, after 43 years, no, not correct. You are well aware about the same proceedings. No, the petition is a fence sitter. You are a fence sitter. If the award is made, you will entitle for compensation. Otherwise, better it should be like that only. That cannot be accepted. Let us will. No, sir. Delay is. No. Sorry, sir. Sorry, sir. Next month. That even otherwise, that is sense of after acquisition. After acquisition.
Proceedings were initiated by the 2018 there is need for
Yes. You 43 years. Not a case. Sorry. What your challenge is the order of 80. That's what. What is your prayer actually? Previous. Which order that you are challenging? Please read your prayers. What will happen in so far as the amount is now deposited? It was remanded twice. It was remanded twice. No, the land tribunal order. Then EG accept notice for respondent issue emergent notice to 3 to 5. In the meanwhile, all further proceedings pursuant to order dated 6/5/22 in LRT number 847 of 80/81 passed by the second respondent is stayed till next time. Nothing. Yes, sir. Annexure E, sir. What has to be considered? What is to be considered? ಮಂಜೂರಾಗಿದೆ ಸದ್ರಿ ಕೋಡಿ ಮತ್ತು ದುರಸ್ತಿ ಮಾಡೋದು ದುರಸ್ತಿ ಥ್ರೂ ಆನ್ಲೈನ್ ಅಲ್ಲ ಈಗ ಯು ಕ್ಯಾನ್ ಅಪ್ರೋಚ್ ಆನ್ಲೈನ್ ಆನ್ಲೈನ್ ಓನ್ಲಿ ಪ್ರೀವಿಯಸ್ ಕೋಡಿ ಅಂತ and EG accept notice for respondents. In this petition, the grievance of the petitioner is with regard to conduct OD and duress in respect of the subject land, and accordingly he has approached the respondent authorities as per annexure E. Full stop. It is submitted by the learned EGA that the petitioner be permitted to approach the competent authority through online, and in that event the same shall be considered. Recording the submission made by the Learned Council, Learned EGA, it is open for the petitioner to approach the competent authority by making application through online to conduct OD and duress in respect of the subject line. If such a such an exercise is made by the petitioner, same shall be considered by the respondent in accordance. Who is this assistant commissioner has passed an order? See, you see the order sheet. Annexure J. Let you will present before a court. Let you will explain. How can you pass this order? ಪೀಠಾಧಿಕಾರಿಗಳು ಇತರೆ ಕೆಲಸಗಳಲ್ಲಿ ನಿರತರಾಗಿದ್ದಾರೆ. ಇತರೆ ಕೆಲಸದಲ್ಲಿ ನಿರತರಾಗಿದ್ದಾರೆ. Then you pass order. This. Let you will present before the court. How can you pass on a posted for orders without hearing it? And how many times? ಅದು 13-14 ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಒಂದ್ ಹಿಯರಿಂಗ್ ಬಿಟ್ಟು ಇನ್ನೆಲ್ಲ ಪೀಠಾಧಿಕಾರಿಗಳಿಲ್ಲ, ಅವರು ಪೀಠ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ. What is this order? Then at AG accept notice for respondents. Stay of further proceedings in LND.RUO number 5 of 2021-22 on the file of the second respondent within bracket annexure J until further orders. How can you pass such an annexure? Only thing is annexure NPQ has to be considered. Yes. That we will see what they will do. You want dispossession? You want dispossess? I can record your submission. That they will take decision in the matter. Then at AG accept. No interment. Let they will consider. No, whether the land is within the purview of Gramtana or not, only that it is in their domain. No, let they will consider it. Let the deputy commissioner will.
There is a here in another calculation from last 30 years. And how much respondent has to be option.
I will tell them to consider it. Then it, no, then it, just a minute. Notice for respondent number 150. Is the grievance of the petitioner that the respondent government has acquired the land belonging to the petitioner with an object to shift the village community of the entire Gollarahalli, Channagiri Taluk from the existing place and in this regard existing place for the purpose of the Tungabhadra channel for construction of Tungabhadra channels. Is contempt in the backdrop of these aspects. The petition hearing has submitted that the respondents have approached the first respondent hearing as per annexure M, deputy commissioners to consider the case of the grievance of the petitioner for granting land to the petitioners wisdom. In that way of the matter, without expressing any opinion on the merits of the case, the respondent number 1 shall consider the representation dated 7/10/2023, within bracket annexure N with an outer limit of 3 months from the receipt of the order.
If land has not been utilized, what is what land has
Now they will take decision. Now they will take decision. Now they will take decision. Let us use. No, no, anyway, let they will consider within 3 months.
the order of discourse, but not to discourse until the decision or any order passed.
That could be done till the consideration of the representation made by the respondent number 1. No precipitative action shall be taken against the petitioners. Against the petitioners. Next matter, let us. Yes, ma'am. Direct the respondent surveyor to measure the line. Surveyor, you approach the authority. No, for OD model erection. OD means you have to approach the competent authority through online. Yes. Annexure D now. Yes. There's a directorate of the land records. Notice in it, Alate Kalsa Puraichi. Only thing is you have to effectuate the order passed at annexure D. The director has stated that the Alate Kalsa Madi Puraichi Agatya where you approach the you cannot approach a surveyor, you can approach the competent authority. There Tahsildar Bartara, Tahsildar has to be. That cannot be done. You are given to the Rajanakunta police station, they cannot do it. No, who has to conduct survey? Then you have to approach them. Then you have to approach the surveyor. Where in this petition that you approach? In which representation that you approach there? Not orally. You approach the competent authority. You approach the police inspector Rajanakunta police station. Police cannot do survey. You can approach. You file appropriate petition representation to the respondent number 3 that he will consider. It. I think survey means who has to competent authority to allot a survey. Surveyor. That respondent number 3 shall be director. Same shall be considered. Who has to? Yes. You can approach child respondent now. Madam, you approach a police inspector. Where is that approach? Where is that? That you are not produced, you are not approached. That's why I'm saying one cannot AG accept notice for respondents. You make one more representation within the time frame. Done everything, but it's not there in the writ petition. That's why. Heard the land. Let it be there only. Let it be there. Land AG accept notice for respondents. In this writ petition, The grievance. No, that representation is not part of this record. Yes, please. Even same office. From revenue secretary to the down the line, same office, but you have to approach the competent authority.
He's saying, I was not that guy. I was not I was not, you make fresh application. But what are these things? They are not the things, what are they? The direction is moving. When he is out to do the finding is not the. Again, representation, there is right to the testimony. They are not like actors anyway. If there is no ordinance, I have represented. He cannot say, I can, he can be so important. Then he can be what is it? The target has to be related.
Hardilana Council appeal for the parties. In the under AG accept notice for respond number 1 to 3. It is the grievance of the petitioner that the petitioner is the owner in possession of the land in question, seeking Kodi in respect of the survey number 6 to an extent of 14 guntas. And in this regard, the director of the Bhudakara Sahayaka Nirdeshak, the second respondent herein has passed an order dated 22/11/2022 within bracket annexure D, and directed and observed that the land in question has to be surveyed and sketch has to be prepared accordingly. In that view of the matter, I'm of the opinion that the petitioner herein shall approach the respondent number 3 along with the copy of along with the order dated 22/11/2022 within bracket annexure D, passed by the respondent number 2 within 2 weeks from the receipt of this order. In the event if such a representation is made by the petitioner to the third respondent hearing, third respondent shall consider the same within 3 months from the receipt of such representation. With this observation, writ petition is disposed of. I don't know. Next matter, ladies. 3 months, 40 gala 3 months. Yes. What is this series of matters? By special order, sir. 48. Okay. I thought B group. Sorry. Annexure P is challenged. So vacate and take over. Let there be a stay. No, don't take. Let us use. Otherwise it will. Immediately take decision. That cannot be done. Correct. Yes. It's a special deputy commission. No, it said seconds. Yes, that's why I said it's a special deputy commission. That's why you passed. Don't evict. Don't remove the encroachment. Bernard. Notice. But inquiry has to be conducted. Inquiry, unless you conduct an inquiry, you cannot do it. Then at AG accept notice for respondents. Third, Sri G. Krishnamurthy Lana, Senior Counsel appearing for the petitioner and the AGA for the respondent. Is contended by the Senior Counsel appearing for the petitioner that the impugned order passed by the respondent number 1, respondent number 2 is contrary to the earlier order passed by the Deputy Commissioner excluding the land belonging to the petitioner from the inquiry. In that we ought to matter, let there be a stay of the order dated 20th October 2023, passed by the respondent number 2 within bracket connection P till next attack. It is anyway the matter is also. Then this order goes subject to the order passed by the division. Once the land is excluded, then that we done. Today itself it will. Yes. Anyway, the rider is before the honorable division bench. Yes. Yes. Why this series of matters? That side is other side. The other side is there. Oh, 5A PTCL.
That is, the document is not available.
Contesting response, one opportunity. Petitioner is present. No representation on behalf of the private counsel appearing for the private respondents in order to provide an opportunity to the counsel representing a private respondent. They just matter after 2 weeks to 28. Let us fix. We will take it up on. Yes. Yes. Just 1 minute. First impugned order at annexary L and J. What is L and J? Abstain commission on what ground? 36-35, yes. Has been allotted in favor of the respondent number 3 to 5 and 8. Daring. Then you have to prove that you are a member of the joint family. Nucleus. Connection? Connection? Yes.
Partition should between the family members of the and the ratio of care was divided at the rate of 1:1:1. And the improper as the land is western
so the entry has been made subject to has been made taking into consideration the judgment and decree in OS number 3634. If you have any grievance,
in the year 2001, The Tahsildar had appeared before the Tahsildar, sought for mutation in it. The Tahsildar
So
had
ultimately, the revenue authorities have followed the judgment and decree in the OS. If you are agreed,
judgment is that has not been followed.
but you are a party in 3634 Allah.
Well, so I'm not a party to this.
Where is-
It's one of the factors. One of the shareholder. Where are the three?
Just one. Who are you?
I am one of the family members of the Regularization. I have taken one of the share has been received there. She however decent rate of.
Then challenge that the judgment and decree.
I have a degree. And
Then challenge that. No. Then challenge.
subsequently,
Yes, then judge. Anyway, now you came to know about the judgment and decree in 3634 of 2005.
Design is for 2005 degree. Whereas it has not been designed for something.
That's why you challenge this. That's why you challenge the judgment and decree in OS.
Because RFA degree is something in 1977.
Yes.
RFA is something in 1977. There is a degree and this language has been clearly mentioned and the ratio has also been derived there.
Yes. But,
One of the shareholders.
but subsequent decree is there.
Not against me.
Subsequent decree is there.
I'm not a party. I'm not a party to those proceedings. I have no one concerned in that too. I'm concerned in the RFA of the year 1977.
Who appeared for him?
You didn't admit my share in the mutation proceedings before the last.
But these are all disputed question of fact. Whether the land belonging to you or not. Yes, yes.
It is the order passed in my favor by the Tahsildar. At page number 71.
Whether you are a party in RFA?
I am party now.
Huh?
My father was party.
H.N. Venkatesh Reddy.
My father, the respondent's father, party in the article. Now, one of the shareholder who entitled money for 1/3 share, their children file an interstate partition suit and include this property that was standing in their father's name, who was the elder male member of the family.
Anyway, the RFA is already concluded. Let us see. Other side, let us see. One more opportunity. And a counsel appearing for the petitioner is present. No representation on behalf of the Lana counsel representing the private parties in order to provide an opportunity to them. This matter after 2 weeks. Let us will. No, not now. 21 matter. Yes. Make it up afternoon. Afternoon. Yes, madam? No, no. 2:30.
My lord, may I make a submission?
58. You are for the 58 only. At the request made by the petitioner. List of the 2 weeks. Oh, 23 order.
My lord,
Yes, madam.
serial number 55, I appear for the petitioner, my lord.
55, madam.
I pray for a
Finally, at the request made by the petitioner, list after 2 weeks.
Please, my lord.
Yes, sir. Just 1 minute. Just 50? 59, sir. Just one at a time. 59, sir. 23, Allah. This after 2 weeks. The request made by the petitioner list after 2 weeks. 11 is over. Res judicata. Res judicata. 11. We 6 times. Some other matters, sir. 23 matter.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 59 ಅರ್ಜನ್ ಆಗಿದೆಯಾ ಕೋರ್ಟ್ ಆಫೀಸರ್?
ಹೌದು ಚೆನ್ನಾಗಿದೆ.
ಥ್ಯಾಂಕ್ ಯು.
government advocate.
Court officer, court officer,
ಸರ್ ಹೇಳಿ.
ಯರೂರ್ ಸಾಹೇಬ್ರದ್ದು ನಡೀತದ ಮೇಡಮ್ ಈಗ?
ಯರೂರ್ ಸಾಹೇಬ್ರ ಅಲ್ಲ ಸರ್, ಇದು ಇಂದ್ರ
ಹಾ.
ಸಾಹೇಬ್ರ ಕೋಟ ಅಲ್ಲ.
ಓ ಸರಿ 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 ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
What is challenge? Yes. Yes. When was your father secured got the property? When was your father? How your father acquired the property? Partition. In 14,992. And thereafter, in favor of HS, they have sold it actually. And then, yes, yes. Now, what is your share? How, what was the share of your father and where is the sale deed actually? Annexure C. One name. Yes. What is the share actually? ಒಂದು ಎಕರೆ 34. What is the total extent? 18 guntas. But what is the remaining extent? It has to be other thing. What's the remaining remaining extent? Yes. What is the extent of the petition, sir? Where it is? In which annexure that you say that annexure J? Page, sir? 47. ವಿಸ್ತೀರ್ಣದ ಬಗ್ಗೆ ಜಮೀನಿನ ಪಹಣಿ ಕಾಲಂ 9ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ ನಮೂದಿಸುವ ಬಗ್ಗೆ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಬಹುದರಿಂದ ಪ್ರಸ್ತಾವನೆ ತಿರಸ್ಕರಿಸಿ. ವಾಟ್ ಇಸ್ ಯುವರ್ ಎಕ್ಸ್ಟೆಂಟ್? How did you acquire that? Correct. Correct. And what is your extent actually? He is the son. You are the son. Then Await service of notice of respondent number 5. That cannot be. Let us use only the others. Await service of notice of R5. Yes. Yes.
Right, bro. I think it only the second responding order, which is J, which is the order, but if no.
The granted line. Next.
Only was a calculated slab. What's the non-competitive? How you spend it?
No, this is relating to where is the grant where is the grant order? Annexure A and B.
13 December 1935, 38.
Where is the name of the petition? Annexure B.
15 now.
Yes, sir. Where is annexure B?
It's my grandfather. Survey number Muniga. Number 60.
Survey number?
Muniga. It's my grandfather.
Yes, sir.
C is the body. We have to make sure D is an application defined petition grandfather regarding.
Yes, sir. Yes. Now, which order that you are challenging? Which order that you are challenging? J.
Number 36. Also, you know, the appeal, for the DC,
One minute. Next G. How you have agreed by this order?
the department is to order, when you use my land, landed land, no only to the not is there, can't prove that, so this is the problem.
Correct.
Also pending is appeal pending to put the argument in audit number 21 days remain pending consideration. Please note that sir, is taking response for this order. Please consider the body fixing that already and given thing relevant.
Yes, sir.
Going fully available, we want this order. We don't have the prisoners. It's done in the now.
Which is your survey number actually? This is also there here. ಕಾಣಿಸ್ತಾ ಇಲ್ವೇ ನಿಂಬೆಕಾಯಿ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ ಬೇರೆ ಸೀಲ್ ನಂಬರ್ ಎಲ್ಲಿ
C14. Intake act.
Why the government has, yes, sir?
Petitioner and owner and the restitution saying he with granting whoever. There is no document or no feeling that the petitioner and so-called grant. The joint first, second admission is.
You are saying that he is not the grandson of the grantee.
My second admission is with respect to the same land, that another claiming clause, that is one, who is also claiming the very same land. And the restitution also has been filed. And in the restitution law, the court has directed the petitioner to get the relief from the competent court. If the petitioner is also claiming the very same.
Same. Yes, sir. Which is that? Which is that petition?
But I have produced the certificate copy of the order. 175 of 2000.
So far as the very same.
Impleading application act are in order to separate and have to the court of
Yes, sir. You can establish your right. Anyway, this court has already. You establish your right, and in the event if you are entitled. No, already this court in so far as the very same survey number has relegated a party to approach the civil court. Same thing will happen. That is only an ISA number. Establish your right over property then. But you have to establish your relationship with with the grantee. What will? Anyway, this court has already directed the other claimant to approach the civil court. Even in the very same proceedings, the the said petition also the petitioners claims that the grant order is 31/7/1962. Even that is also subject matter of this. Correct. First step. This precedence. Establish your rights. In this petition, petitioner is assailing.
What is our land value? Land is
First,
Single concept is in my area.
the court first establish a relationship with the grantee.
I mean, that was, let's say the 41 there, the 44, see the.
Because a rival claimant, although the petition,
We got.
you have the, that cannot be, that's a part of the petition. Even the relationship with the money guy is disputed by the other side.
There's no comment, but land is only number.
But no, you only know, no, you only know, they don't know. That's why you establish. That's why.
Because they are taking something downstairs, because they are escaping from downtown.
Correct.
Can you see what it is? Number 44.
That also. Very nicely written.
Muniga, grandfather, same is right of Niyama. First son of Allappa, second daughter of Niyama, and first son of Allappa. This is the Commissioner. Allappa,
That is what they are saying, that you established that. Now what you have written, read it now. You established that first. That's what even the court in the earlier occasion in this. The rival application is also filed in so far as the very same property. In this petitioner is assailing the order dated 24/5/2018, within bracket annexure J, passed by the second respondent in respect of the land bearing survey number 52 in an extent of 2 acres at Nimbe Kaipura village, Bangalore East Taluk. The relevant facts for adjudication of this petition are that it is the case of the petitioner. Please answer. It's the case of the petitioner that the land bearings 2 acres of land in survey number 52 of Nimbe Kaipura village, Bangalore East Taluk, was granted to one Muniga is stated in the writ petition. Where is stated as his grandfather? Where you stated is a grandfather?
Not me.
Yes. Where you stated is a grandfather? Predecessor Allah. Grandfather. That's why this court is. It is contended by the Lana Council appealing for the petitioner that the original grantee is the grandfather of the petitioner. It is further covered in the petition that the the respondent government has conducted duress in respect of the survey number 52 as per annexure E. During the 26117, it is further stated in the writ petition that one Chikka Narayanappa had filed WP number 26175 of 2019 before this court, challenging the order dated 10/8/2011 passed by the Special Deputy Commissioner East Taluk in respect of the survey number 52 within bracket new survey number 52 bar P-03 close the bracket of Nimbe Kaipura, Bangalore East Taluk, and in the said writ petition, petitioner has made an application to implead, and this court by order dated 13th August 2021, dispose of the said writ petition, relegating the petitioner therein to approach the civil court for establish his claim for the title in respect of the subject class. It is the grievance of the petition hearing that the respondent authorities without jurisdiction have passed the order dated 24/5/2018 within bracket annexure J, and and the land belonging to the petitioner has been ordered to be taken for construction of the sites / residential premises to the land less to the to the uh, to the landless persons. Full stop. In the being agreed by the same, the petitioner has approached this court. I heard Mr. So-and-so, Lana counsel for the petitioner. Madam so-and-so for the respond number 2. Sri Anamantappa Ravi Gowda Lana counsel appearing for the petitioner. Contended that the impugned order produced at Annexure J has been passed without hearing the petitioner, and the land in question has been granted to the grandfather of the petitioner, and without giving an opportunity of hearing to the petitioner, the impugned order at Annexure J has been passed. Accordingly, contended that the impugned order is liable to be set aside. Per contra, Madam so-and-so and a counsel appearing for the respondent number 5 disputed the relationship of the petitioner with the original grantee as contended by the learned counsel appearing for the petitioner. She also made available the order dated 13th, the copy of the order dated 13th August 2021 in WP number 26175 of 2019, wherein one Chikkanarayanappa has made an application seeking grant of the very same land and this court by order dated 13th August 2021 dismissed the petition, and as such reserved under liberty was reserved to the petitioner therein to institute civil suit to establish his claim over the title to the land in question. That way of the matter, she contended that the petition hearing is also to be relegated to the civil court to establish his right over the property in question. Learned AGM so-and-so sought to justify the impugned order. In the light of the submission made by the learned counsel appearing for the parties, on careful examination of the writ papers would indicate that as per annexure A and B, where is the grant? Where is the grant certificate? No, that is not grants. And taking into having heard the learned counsel appearing for the parties, on perusal of the letter order dated 13th December 1938, annexed with the annexure B, wherein a report has been made to the government to grant land to one Muniga in survey number 52/3. However, undisputably the grant certificate nor the Sagavali chit is produced in the writ petition to establish that the land has been granted in favor of the grant. Annexure? That is not the same. What is it? Sagoli chit you have to produce. It's not Sagoli chits. That they have written actually. Sagoli chit Vaya. That's not produced in the writ petition. Yes. In that way of the matter, taking into consideration that a rival claim has been made insofar as the very same land, and this court in the aforementioned writ petition, relegated the petitioner therein to approach the civil court to establish his claim over the over the property in question. I'm of the view that the petitioner has not made out a case for interference in this writ petition. however reserving liberty to the petitioner to approach the competent court to establish his claim over the property in question. With this observation, the petition is disposed. Yes, sir. Possession, that is IA number 1 in the suit. No, IA number 1 in the suit seeking injunction. No. That cannot be. No. First you establish it. Prasanna BR. Yes. Just 1 minute. So your challenge annexure K and L. K and L. Very same order in the previous. Same order is. Maybe in that case he has to establish. Here you have to do something else. Yes. Petition number? What? Yes, sir. Land was granted. When? Where is the grant? Annexure B is the grant certificate. It's issued in favor of Munidasappa. How is related to use? Munidas, correct. Yes. 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 Annexure G. Page number? 1 minute. 62, yes. 136 class 2, yes. So this is filed by the petitioner. What has happened? Yes.
And the
Yes.
government itself told that the land is land.
Yes.
The item number 44. And then it ought to
Annexure. Sorry, serial number 30. 34. 57. Okay. Yes. Yes. So what is the submission is that since it is a land granted to his grandfather, yes, annexure J. Page house building. Yes. Correct. Not served copy to the petition. Can it be taken up anything? Whatever the date you say, at 2:30 I will take it. Anyway, what the
The fact that not from 2000 not from 18 long years not nothing.
but what has happened? The assistant commissioner.
It's like onion.
Let they will serve copy so that he can have the benefit of the. Let they let us will see. When it could be taken. Next week 2:30. Next week any date in 2:30. So that you have to get the records by the time. One serving copy, second one is secure the records. Yavati. Yes. Any day, whatever the day you all of you say, they will. No, it's only to fix the date. That's all. 15, sir. When it would. 9th. Go for judicial. 6th, sorry, 6th. Oh, that is October. To change. 9th, yes, just a minute. Next Thursday it would be taken. It's not correct. They seek urgency, then you cannot. When other side is seeking urgency, now I have to say that that's on merits. Only for hearing the date. Line. Learned AG is directed to secure the records from the competent authorities. This is matter on 9 for further hearing. Yes. Yes. Interim order granted earlier, extended till next. 9th at 2:30. Yes.
My lord, on submission, my lord, in the same case.
Ah. 56.
My
Say
lord.
that.
My lord, 54.2, my lord, I am appearing for the respondent number 1.
Yes,
In that, my lord, it's
It-
urgent to 9th, madam.
9th, madam. 9th. It will
Madam,
take up.
14087.
Yes,
And
madam.
one more case, my lord, it may be tagged along with that, my
Yes.
lord.
Yeah, what is the number?
14087 of 2022, my lord.
140
It may be tagged along with that, my lord.
tagged along with
87 of 2022.
No, it's not correct.
Along with 54, my lord, serial number 54, my lord.
No, we're not hearing properly. What is the WP number?
14087 of 2022, my lord.
14087.
WP number 14087 of 2022, my lord.
14087. Tag along with zones. Yes, madam.
Yes, my lord.
Yes, madam.
This
It will
case
be
also
taken up.
tagged along with serial number 54,
Yes, yes,
my
done,
lord.
madam. Done. It is done. It is. What your challenge, sir?
Thank you. Much obliged.
What your challenge? ma'am? But 136.3 ಅಂತ ಇದೆ. Annexure A is challenge. 136.3. Taken up after 2 weeks. No. At the request made by the Nana Council applying for the petition, just after 2 weeks. Now only Chandra L ಮಾತ್ರ ಅಲ್ಲ, Shaikh Ismail ಅದು delete ಮಾಡಬಹುದಲ್ಲ. Registry is directed to delete the name of Shaikh Ismail Zabiullah and to retain the name of Sri Chandra L for the petition. Yes. But one minute. One minute. Mandamus separate direction to the Tahsildar. But 2000. But what has happened for nearly 23 years? What happened in 23 years?
They have not complied with what.
Contempt. Revive this then. Revive the contempt. No.
Because the grant was already made. The next step of issuing is now that is to be done. That was not done. Therefore, I tried the present petition. When they have made the affidavit saying that, then on appeal, pending the deputy commissioner, therefore we are not in a position. I think that is not the case. There is related to different survey number, not survey number. That is 71.
Now what is the order that you challenge? But two.
Because the
See, this is the second repetition on the very same ground what you are urging in Annexure B. Earlier occasion. Then on the very same. The complaint then it is open for you contempt. You can file a contempt. I know. That's why paragraph 3. You see in the contempt order. The accuser so and so furnish an undertaking that you would immediately place the case of the complaint before the regularization committee, and the said committee would pass the necessary orders. You, how can, see earlier petition on the very same relief. Yes, that's it. But what has happened earlier? You said so. The same relief now you are claiming. You can invoke. You can invoke the contempt order in the event. Because on the very same relief, you cannot start in the second petition. No. No. In the earlier writ petition, annexure B, to issue. No. No, that's what I'm saying. Your writ petition is to issue Sagavali check. That will complete again. Consider the petition for issue in accordance with law. Content. No, not comply.
Maybe the definition of the undertaking, not undertaking. That we immediately is the case of the complainant
before the committee. Yes. So what has happened in the committee actually? Will be placed before the committee. What will happen before the? No, what is the outcome of the committee? Order passed by disputing committee was not brought to my knowledge. Due to inadvertence, the case of the petition for issuance of Assembly Secretary, an appeal has been filed by the petitioner. You have filed an appeal.
No, that is in respect of different survey number. They have filed an
RAP 77 of the. You got to file. How can you file then? Then it's a wrong affidavit. Then it is a wrong affidavit. No, you see your affidavit filed by. No. You have the copy of the affidavit. You have the copy of the affidavit. Just 1 minute. Go to paragraph 4 of the affidavit. Please read. Not placed before the committee. Then you committed a wrong. You committed. Yes. This is an affidavit you have filed. But which survey number? Whether it is pertaining to very same number? No. No, just. No. That you will argue the matter why you are saying. Ala, he is arguing the matter. Can I dismiss this petition? Saying that you are not proper. When you are arguing, you start to interfere. You sit. You sit. It's not correct. When you are making, just check. No, what was the land granted to him? The survey number? Yes. Okay. 45/2. That is annexure A. To an extent, a total extent. No, I'm not. No. What was the land granted to him? No, you go by no instruction as per the what was the land granted to the petition? In the event if we're looking into the days, the petition is then it's nothing but perjury by the day. He say that I humbly submit the order passed by was not brought to my knowledge due to inadvertence the case of the petition for issuance as per the direction. Court could not place before the committee. Then it's a violation. Instead of but it is granted as per annexure A. Proceedings. Where is the grant then? Just I will. Where is the order of grants? Which one? Which one? Not proceedings. So where is the grant actually? But it has to place before a committee. How can you? No, that's as per rules. Karnataka land revenue. It has to place under 108. It has to be placed before a committee.
they are making different interpretations.
So now you just to show me where is the grant. No. Nadivali, you show me the grant. If you show me the grant, then only I can say that can ask them actually. No, sir. Sir, procedure is contemplated and then that has to be followed. See, if you look at 108, when an application is filed by the by the applicant, whoever may be, it has to be forwarded to the committee. Then committee has to take a decision. 108I or K somewhere else. Yes, that is the law. Now you show me when it has been placed before the committee. When yes, committee. At the council appealing for the petitioner submitted that the petitioner first up, petitioner will produce the relevant document before this court with regard to the grant of the subject land bearing survey number 45/2 and survey number 101/1 of which village? Which village? Kiran? Kilinjaru village of village Mangalore Taluk. Full stop. Mangalore Taluk. Leonard EGA. Full stop. On the contrary, Leonard EGA submitted that annexure A and B are the proceedings, and the case of the petitioner was not placed before the committee for grant of the subject land. In that way of the matter, the petitioner is directed to produce the grant certificate issued by the competent court and the relevant documents relating to the resolution passed by the committee based on the application made by the petitioner to the based on the proceedings referred to at annexure A. Yes. Let us move. He is your Tahsildar. He is your Tahsildar, not our Tahsildar. The Leonard EG is directed to secure the original records from the competent authorities. Competent authorities. Yes. Yes. Unbelievable. I think so. Okay. 2:30 then. Not it. First. Cyber ಬಂದಿದೆ ಯಾವತ್ತು Yes, sir. Which serial number? You get. I think there are two matters. First one was disposed of. Dealing ಮಾಡಿದೀವಿ. ಹೌದು. So that was dealing. How it could be done? Now it cannot be done. But if I remember it, I remember that first writ petition has become infructuous. That you should have stated second one. You move it. Signed. You move it. Big and spoken, it will be rectified. Do one thing, both the matters has to be listed. Because you move it, it will be listed for being spoken to. And thereafter, very same day, it will be, other matter will be listed. Be very careful in connected matters, even when we used to pass orders and sign, sometimes there will be some problem. Connected matters, we should be very. Today it was 136.3. How did how the assistant commission under 133.3? Just you open that, say that 136.3 ನಲ್ಲಿ order ಮಾಡಿ. Let us see. Just please. Answer. Just.